that was rejected because that was something that Glencore was already doing, and the notion that they were offering a concession that was the fix that Mr. Glencore was already, or that Glencore was already pursuing, really outraged Glencore. He said Battalion was offering an ability to blend some WTI into their regular stream on one point, the 3,333 a day. They were not offering to give us back a WTL barred on a dock, which is the service we were paid for. And then on point two, they are offering a solution to go to the Pin Oak dock, which was already what Glencore was doing. This infuriated Guy, as Guy was already moving barrels to Pin Oak. So they gave him a solution that was already what Guy was doing himself. Guy did not want Pin Oak loading. He struck this deal as the Epic dock, and that's what he wanted.
Okay.
Okay. On materiality, there unquestionably, this was material at the time the contract was signed. Unquestionably, it was our thesis. It was a subject of discussion. Everybody recognized that it was material at the time we signed it, and it was the thesis under which we entered into this deal. Later, as performance was underway during the first year, clearly it was material because Glencore, and we were reimbursing them, and I believe we identified our reimbursements to Glencore during Mr. Wishoff's testimony. Those were a whole series of exhibits that were identified. Changed the economics of the deal because we had to pay these pump over fees. And that made it material at the time as well, because clearly we had sufficient oil to fill a tanker in excess of what we were getting at the Epic terminal. And I can't think of anything more material than the fact that we were not getting what we specifically bargained for, and we were incurring costs to secure that somewhere else. I mean, we're entitled to the benefit of the performance that we bargained for. And I know you have these two specific questions, and I may ask Mr. Scheck to add a little bit to what I've just said, but I want to first say that, you know, we have a great deal of respect for our adversaries, and Mr. Carter has done a good job in this case. But I'm assuming that this was an oversight and he was not intentionally trying to mislead the court. But if you look at, I don't know whether you guys can put up your slide 30.
Yes, Mr. Spalding, slide 30, please. We may need a screen share enabled for our side.
Well, it was not slide 30. It was the slide where you had 3.1 of the terminal services agreement. Ah, okay. It is. All right.
Yeah.
All right. I'm sorry. I was looking at the bottom part. Mr. Carter put this up and he showed you this section 3.1 from the respective commencement date for the initial terminal and new terminal as applicable through the remainder of the term. Medallion shall provide or cause to be provided the following services, together the services on a firm basis. And he showed you number C. And he said delivery of crude petroleum to vessels at the initial terminal at loading rates of at least 20,000 barrels per hour. And he told you that this was an Aframax loading rate. And therefore, all we were getting under this contract was an Aframax loading rate. And that was all we should expect. But what Mr. Carter neglected to do in this slide was show you subparagraph D. If we could put up Plaintiff's Exhibit 2 at page 7. Yes, that's it. Why don't we show C and D together? We didn't just get 20,000 barrels per hour. They promised to give us delivery of crude petroleum to vessels at the new terminal at loading rates of at least 40,000 barrels per hour, which everybody who's testified about this has agreed, a Suez max.
And can I add one thing to that point? If we could go to 3.4E, please. Sorry. And this is the table that Mr. Carter showed the court. This is the loading rates. And the slide you looked at shows 300,000 or more is limited to 36 hours. But I'd like to go now to just the next line below that, point 2. It says, for all lay time used in excess of the allowed lay time, Medallion shall pay or cause to be paid demurrage. That is the only consequence of that table, that Medallion has to pay demurrage. It doesn't mean that we're not allowed to load in excess of 36 hours. It just means that Medallion has to pay for it.
Look, there is, I mean, Your Honor, I know that, you're not steeped in the energy trading business or the midstream business, although I think you've probably learned an awful lot over the last.
That's definitely true.
Yeah, but it's with that complexity, it's really easy to do a lot of sleight of hand. And again, this is not directly responsive to your questions, but it just raises the kind of concerns I have with the sleight of hand that we've seen from the other side. We talked about committed firm service, and Mr. Carter suggested that committed firm service means, if they're not shipping WTL, then that's not their highest level of, then you're not entitled to it because it's not the highest level of service. And I just want to show you, if we could look at PX4, I think he represented that there was nothing in the contracts that said that this highest level of service related to this priority issue that Mr. Wishoff testified about. Well, if you look at PX4, which is the EPIC tariff, on page 6, it has a definition of firm service. And, without the sleight of hand, firm service means the type of premium service provided to committed shippers. Under firm service, committed shippers pay premium committed rates relative to uncommitted shippers during prorationing months in exchange for not being subject to proration on the lesser of their monthly nominated volumes, or MDQ. This is just another example of.
Can I say that this to you? You never been on court, so I've already made decisions about all of this stuff except for those 2 points, and I feel like you responded to those 2. So I'm ready to rule whenever you're ready to finish.
If Mr. Scheck could just make one other comment on materiality, he's been giving this a lot of thought.
Yes, good afternoon, Your Honor, and I'll keep it brief. I think taking a step back, Medallion's completely misunderstanding the concept of materiality, because their theory appears to be that they don't have to provide the services that they agreed to, and we still have to pay for them, and we still have to provide credit support, because they don't believe we could execute on an investment thesis. That's not how materiality works. The first thing is the benefit of your bargain. That's, did you specifically bargain for these important provisions? Nobody can deny that WTL and Suez were at the center of these contracts. In fact, the only person from Medallion, and the evidence reveals this, that was truly negotiating the commercial terms of these contracts, fully admitted the materiality of these provisions. There's no doubt that they're material. But the bigger, I think the last point I want to make about this is that I sort of feel like we've entered the twilight zone as it relates to materiality, because what they're arguing is that we should have bought into the mismatch and sent crude down, even though they had told us we couldn't have a Suez, right? So they say, where's the receipts? Why didn't you have the full capacity to send down to a Suez? But it's because they told us we couldn't have a Suez. You can't negate the benefits of the contract and then say, hey, show me how this contract was beneficial to you. That's completely circular reasoning. We can't establish that we purchased extra barrels, and we already did establish the pump over fees, but the notion that we have to show receipts for buying something that they told us we couldn't utilize and would end up costing us more money is completely absurd. Unless Your Honor has any questions, I wanted to keep that brief, so I'll leave it there.
I think that was an excellent point. All right, are you guys ready? So let me kind of give my, first off, let me just say both sides I thought did an absolutely fantastic job in this trial. You guys were both very prepared. You had great questions. You were very responsive. I always love a good trial, and you guys both, I thought, did an excellent job. I have no criticism of anybody in this, and I thought you guys all did a great job. And so I just wanted to preface with that. And I will tell you that I really went back and forth on this case because I think it's a difficult case, and the way the contract's written. If I was to be a mediator in this case, I would have suggested a very different result. But unfortunately, under the contract, I feel like I have two choices here. Is if I find there's a breach. Then there's the 32.7 million. Everybody's kind of agreed to that. And if I don't find there's a breach, then I have to award damages to the defendant. And neither really seems totally fair to me. But the contract is what the contract is. And so, given the testimony in the case, and I think I kind of, showed what I thought was the most important point, which is, I think if there's one breach, and I think there was at least one breach, that breach was material, then I have to award in favor of the plaintiff for 32.7 million. And so I award in favor of, just so it's clear, I'm awarding in favor of the plaintiff 32.7 million under, or whatever the exact amount of the credit support is. I find there is a breach. Clearly as to the Suezmax provision and I find that's material. I'm going to go ahead and find, I don't know that it's quite as clear on the WTL, but I'll go ahead and find it, since it doesn't really matter, I'm going to find it in favor of the plaintiff on that as well. I do want you guys to revise your Mr. Stern or Ms. Shee, I don't know who's going to do this. I want you to prepare findings of fact, conclusions of law consistent with my rulings. Make sure you share those with Mr. Carter, who's I thought did an excellent job in this case, or whoever the appropriate person on the other side is. And then we need to decide on the issue of, and of course, I'm going to award prejudgment interest. And then you guys just let me know how you want to deal with attorney's fees. I think you had said you were going to do this maybe by, I'd rather do it in person, but not in person, but do some kind of live testimony at some point. But if you guys can reach a stipulation as to an amount, a lot of people do that in cases like this, at least here in Dallas. You don't have to do that. If you need to have another evidentiary hearing on that, I'm happy to do that. Or if you reach an agreement, or if you want to submit affidavits. So just let me know on that. Any questions about my ruling?
Not from the plaintiff, Your Honor.
No, sir. Thank you.
All right. Good job by both sides. And I enjoyed working with you guys. Try to get that to me by Friday. The proposed findings of fact. You guys aren't shut down in Houston, right?
No,
We're not.
Yeah, the county is completely shut down. So, but is Friday a reasonable amount of time, Ms. Shee or Mr. Stern?
Yes, Your Honor.
And Mr. Carter, I know you have another trial coming up. Will you have someone in your office who can deal with these issues?
Yes, Your Honor.
And then also try to get me proposed findings of fact, conclusions of law. We are going to do, I don't know if this is how they do it in Houston. I put cases, once I've made a decision on them or there's a jury finding, we put you on a 30-day dismissal docket. So if you get a notice like that, it's because we want to get a judgment in within the next 30 days.
All right. Thank you.
Thank you, Your Honor.
All right, guys. Good job. And that's it.
All right. Thanks
Thank
much, Judge.
you.
Thank you, guys.